6 steps to a winning closing statement coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. I'm Jordan Farkas. If you have subscribed already, thanks so much for subscribing. Thank you to our new subscribers. If you haven't subscribed and you wanted to know a little bit more about me before you do subscribe, then you can check out my bio video on the homepage of this channel. And obviously it takes just a second to hit that subscribe button and the notification bell so you don't miss a future video. And I'd be very grateful if you did that. It helps you, of course, and it also helps me to continue to produce videos just like this one to help you win in small claims court, which is my goal. Now, today's video is going to be about 6 steps to having a winning closing statement. I've done a lot of videos already, or a fair bit of videos, about various procedures leading up to this point in the trial, talking about things like what to consider before you file your lawsuit, how to prepare a good claim, how to prepare your evidence, how you link your evidence with what transpired. You can see all that in the videos in my library. And today we've culminated with the point where we're at the trial. You've already gone through your evidence and you're about to give the case off to the small claims court decision maker, usually a judge in most small claims courts around the world. And before you do that, again, in most small claims courts around the world, you have an opportunity to kind of summarize everything that's transpired in the trial in order to lay it out for the judge and make that last impression, if you will, for the judge in order for them to make a decision in your favor. So it's a very crucial time in the trial. Of course, in many instances, the judge will have already made up their mind before you've gotten to this point. And that's why it's so crucial to be prepared before trial and to really start with a strong opening statement, as I talked about in one of my videos, so that you're kind of planting the seeds in the judge's mind. But still, a lot of cases are actually won even at this stage of the trial, at this late stage. Maybe a judge has heard both sides. Both sides maybe sound very credible to the judge, and the judge is kind of weighing the evidence. What do I do? Who do I decide for? So that closing statement can be very important to help get you over the top so that you can win your case. So it's not something to be taken lightly. So with that in mind, and those who are subscribers and have watched my previous videos will be used to my trusty whiteboard, old school. And on the whiteboard, I've written here the title, 6 Steps to a Winning Closing Statement. And I'm going to go through the steps. The first step is to speak slowly. Okay, I actually kind of feel like I've been doing that in this video. I do tend to speak relatively quickly, although I do know that you have the benefit of hitting that pause button when you're watching my video and going over something. So I'm not as concerned here, whereas at a small claims court trial, you don't have that benefit. So all the more reason to really practice speaking slowly. This, of course, applies to all of the trial, but we're talking about closing statements. And in particular, when you're doing that closing statement, because of the very reason that I just alluded to before, that the judge has heard a lot about the case and has heard from both sides, in order to make sure that the judge is getting it, it's a very good habit to speak very slowly when you're doing your closing statement. That will also allow the judge time to write notes. A lot of judges like to write notes, and if you're speaking too quickly, the judge isn't going to catch everything that you're saying. Now, as always, there's all sorts of caveats when it comes to small claims court trials, things that could happen that you may not have anticipated and that you have to pivot from. These are general principles. If you've had a very kind of grouchy type of judge who doesn't have a lot of patience, then maybe you want to kind of up the pace a little bit, but you have to kind of gauge that. I do believe as a general rule, all things being equal and not having an overly grouchy and impatient judge, then you should be in the habit of speaking slowly to make sure that words that you're saying are absorbed, that the judge has time to actually hear. And again, in the case of writing notes, record what it is that you have to say. Oftentimes, by the way, there are court reporters in small claims court, not every small claims court, but there are court reporters. Those are the people that sit in the front that are transcribing everything that's said. And a lot of times they will ask you actually to speak slower so that they can write down, or if whatever the process is, some of them kind of speak into a mic like that. I shouldn't do that for a video, or they're, old-fashioned typing, whatever the case is. But generally, the point is about how to give your most winning closing statement, rather. And to do that, you want to speak slowly to make sure the message is absorbed. So that's step number 1. Step number 2, maybe I should have called these 6 keys as opposed to steps. But in any case, step number 2 is to restate the elevator pitch. So if you watched my video, I'll try and remember, I think the link, if I could add a card to the video. I'm very old school. That's why I use whiteboards like this. I believe I can add a card above to link to that video, if I remember to do that when I'm in the editing process, to watch the video on preparing an opening statement. A lot of these kinds of messages and tips and hacks that I talked about in that video, I will talk about here as well. And that is the elevator pitch. You're going to restate it. What do I mean by elevator pitch? Again, look at the video to learn more about that, the video on the opening statement. But essentially, an elevator pitch is something that you would say to somebody if you're trying to, let's say, sell your business, and you had 30 seconds to do it because you ran into that person in the elevator and they're going to get off at their stop, in 2 floors, for example. So that's called an elevator pitch. And in the case of court, what I call the elevator pitch is really encapsulating your case in even one sentence, arguably, or in as little time and manner as possible, very concisely. So for example, using the classic example that I've been using in all the videos, again, with maybe the names interchanged, you're Jim's Landscaping and you've sued John Smith. You're the plaintiff, Jim, and you've sued John Smith, the defendant, and you did landscaping work for him. So your restatement of your elevator pitch may be, Your Honor, as His Honor saw, this was a lawsuit against Jim Smith for landscaping work that I provided and which I did admirably, on time, and as per the contract, and which Mr. Smith failed to pay me for. That's it. Okay, you're going to get into the evidence, as you'll soon see later on. I'm not saying that's the best possible elevator pitch. Obviously, if this was an actual case of one of my clients, I would take a little bit more time to formulate those words. Although, as a self-represented person in court, don't worry about having to be perfect or having to do one like a lawyer would do one. I happen to be a retired lawyer that did small claims court advocacy for many years. I wrote a book on small claims court. You can see in the banner of the YouTube channel. And you can actually get that free, by the way, on Amazon as an ebook on your Kindle, which is pretty amazing. But in any case, I digress from the shameless self-promotion. The point is that you don't overly think it so that it has to be perfect. You just want to kind of encapsulate your case as best as you can in that elevator pitch. And that helps bring the judge back to really what's going on over here. What is this case about? Because a lot of trials can take twists and turns and go down into the weeds, into places that you wouldn't have necessarily wanted them to go, right? It's not scripted. It's not a movie, as I talked about in the last video. Things go in all sorts of directions. So by restating that elevator pitch, you're kind of bringing the judge back to really what this case is about. And really what it's about is simply a matter of you doing landscaping work and the defendant not paying you. That's all it is. So you want to restate that elevator pitch at the outset of your closing statement. Step number 3 is to summarize your evidence. Okay, so the purpose, when you did your opening statement, what you did was you told the judge what the judge will hear in the trial. You're right. So His Honor is going to see and hear evidence that proves that I did this landscaping work for Mr. Smith. And Your Honor is going to see evidence. It's going to. It's what's going to happen in the future. You're laying the groundwork for the judge. What you're doing now is summarizing what the judge did see. Okay. Now, hopefully the trial went your way, but even if you found that there were some things that didn't go your way, you still want to put your best foot forward by at least trying to kind of massage what happened so that it fits into your claim. That's not to say, I want to be very clear about this. That's not to say you should be lying or doing anything that doesn't speak from a place of integrity, because my videos assume that you actually have a right to the lawsuit that you're bringing. That doesn't mean that there aren't gray areas, okay? A lot of times, both the plaintiff and the defendant can believe in their hearts of hearts that they're correct. So by all means, if you feel you've got a great case, go for it. If you're a defendant and you feel you've been wrongly sued, go for it. You have that right to a court of law to make that decision. But what I mean by massaging is that, let's say things were misinterpreted or did not come out in the way that you would have hoped that they came out. Maybe the judge seemed to have misunderstood something. This is your chance to kind of massage what transpired during the trial into what your claim is about. Now, you have to be very careful, because if you state something as patently not what transpired in the trial, you can get called out for that. Either the defendant could object. Okay, I didn't really talk about objections. I think that's something I may cover in another video as well. Objections means, you may have seen in the movies when somebody gets up and says, I object. Not every court's like that, by the way, but in many small claims court, if you feel that somebody in his or her evidence is saying something that breaches the rules of small claims court, just to use one example, you can interject in the middle to say, I object. And then the judge will ask you, why is it that you object? Okay, but that's for a subject for another video. But the point is that if you say something that is so, not in reality of what actually transpired in the trial, the judge may call you out for that and you can lose your credibility. So you have to be really sensitive to what transpired when you're making your closing statement, because you don't want to overstate what happened, whereas the judge will have a completely different view. So it's a delicate line to kind of massage what happened. By the way, you're not necessarily massaging anything. I keep using the term massage. You're not necessarily massaging anything. Oftentimes, the case will have gone your way and evidence was presented in a way that helps you. So in such case, what you're doing is you're restating that. So let's use a tangible example. So let's say, in this case, I've talked about this in earlier videos. We have and by the way, you've got an evidence brief. See earlier videos about preparing an evidence brief as well. So we have an evidence brief of the documents that you relied upon. So in this case, you had a contract that you showed the court that was between you and the defendant. You had the amount of the contract that was written into the contract. You had emails that proved that Jim Smith had asked you to do some changes to the landscaping work and that you told him it would cost more money and he agreed to it. Okay, you've got photographs. So what you'll do is you'll say, Your Honor, this court has seen, and I want to be clear. So what you're doing here is you're summarizing what happened by referencing the evidence that was presented in court. Evidence, as a reminder, consists of both your documentary evidence, like photographs, emails, could be audio, visual in this day and age, as well as testimony of witnesses. You can also summarize testimony of witnesses. So let's give an example of how that may work. So your closing statement may look something like this. Your Honor, at tab A, I presented to the court a contract that was entered into between myself and Mr. Smith for myself to provide landscaping work for a sum of $5,000. The court saw that subsequent to that contract, Mr. Smith emailed me to ask for change orders. That email was found at tab B of the evidence brief. The court then saw that I responded to Mr. Smith to state that I would do those change orders, but it would cost an additional $5,000. That email is at tab C of the evidence brief. And then Mr. Smith, the court heard, had agreed to that extra amount for the change order. And that email response to Mr. Smith is found at tab D to the evidence brief. His Honor saw evidence that I completed the work, both in the photographs that I presented, which is at tab E, as well as by the testimony of my employee, Harold Bloomstein. I think that was the name I used in my earlier video. His Honor heard Mr. Harold Bloomstein go through in fine detail the work that we did and referencing it with the photographs that are in my evidence brief. And for all those reasons, Your Honor, I respectfully submit that I am owed the $10,000 that I have sued Mr. Smith for. Now, that's kind of the ending. I'm going to get to that in the later steps. But that's an idea of how you go through the evidence, reference where it is so the judge knows where to find it, and really summarize it well for the judge. The judge may be asking you questions, bear in mind, in closing statements, okay? Oftentimes judges sometimes they'll even challenge you. They'll ask you questions because they want to understand the case. Don't be afraid or worried if the judge is asking you questions. I've been at many trials, small claims court and in higher court, where the judge is peppering me with questions, but ultimately that was because the judge was just trying to understand and we ended up winning. So just because the judge may be challenging you, don't get despondent or get concerned that that means you're going to lose. Just be calm and answer the judge's questions to the best of your ability. You always have to maintain that composure. That's not on my list, but that's something I wanted to add as well. Okay. Now, step 4 is similar to step 3, except what you're doing is you're summarizing your opponent's weaknesses. Okay. So not only are you summarizing what went in your favor, you're also summarizing why the evidence did not go in your opponent's favor. So that may look something like this. And again, this is all intertwined with your closing statement. I'm just going in order of my steps, but you can put it in whatever chronology makes sense for you. It's always good to go in chronology of dates, but in any case, so this may be an example. So let's say the defendant got up and had said that he never agreed to the change order of $5,000. So what you can say is, Your Honor, the court heard evidence from the defendant claiming that there was only a contract of $5,000 and that I being the defendant, never agreed to pay $10,000. However, His Honor saw quite clearly from my evidence brief at tabs C, D, and E that there was a clear email exchange between the defendant and myself where he asked for extra work. And I said I would do it, but for an extra $5,000. As well, Your Honor, His Honor heard evidence from the defendant that the work that I did was unworkmanlike. However, Your Honor, I showed very clear evidence at tab E of photographs showing the work that I did. This was corroborated by my employee witness, Harold Bloomstein, who was at the project. And it was also corroborated by my witness, Sally Jones, who is an expert engineer who testified that my work was excellent. And her report that she provided as well was at tab F. So Your Honor, the arguments made by the defendant that my work was shoddy are not supported by the evidence that is before this court. So that's an example of ways in which you can really work to summarize the various weaknesses of the defendant's case. And once again, it's important to do that because the judge may kind of be overwhelmed with all the evidence that came forward at the trial. Don't forget, a lot of these judges are hearing tons and tons of cases every day, okay, or every week or every month. And so it's not like they're necessarily giving it their full attention that you want to give it because it's very near and dear to you. It's your own case. But for the judge, you're just one of many other cases. So by making sure to not only point out the strengths of your case, but also the weaknesses of your defendant's case, you're emphasizing the highlights and strengths of your case, but also undermining, if you will, the defendant's position as well at the same time. So it's a beautiful kind of juxtaposition that you really want to do. And again, how you weave that together is something that you have to work into your closing statement. I do intend maybe in a future video to do an actual intensive workshop as to how this would look like. I've kind of been giving you sort of bits and pieces of examples, but not an actual full closing statement. I think that's a bit overwhelming for you and beyond the scope of this video, but I think you get the point of what I'm getting at here. Of course, if you have any questions about this or you do feel like you need some clarity, especially at the early onset, as the channel's in its infancy, November 2024, as I record this, you're welcome to leave that in the comments. If you have any questions, I'll do my best to address it, maybe even in a future video, bearing in mind that's not specific legal advice for your case. It's just general statements that I could maybe use for videos or for commentary so that other people can learn, but not specific legal advice. Nothing here is ever specific legal advice. There's a lawyer. You can't take the lawyer out of me, I guess, even though I'm retired. Step number 5 is to argue the law. Now, I talked about this in an earlier video. Not every small claims court will have any sort of legal arguments. It's a people's court. It's not meant to get into the law. The law is for lawyers, so to speak. But in many small claims court, including Ontario, where I practiced for many years, Ontario, Canada, there is the ability to make an argument for law. And if that's the case, then in your closing statement, you want to remind the judge about what the law says about your particular case. Okay. And I'm not going to get into specific legal arguments now, but just know that if there is any sort of legal statute or law that you're relying on, or if you're in a common law country like Canada and you're watching this video and there's case law, there's cases, I mean, you have case law and jurisprudence, obviously in the United States and countries around the world as well, but Canada is more of a common law type of country. So if you're, and what common law is, basically common law means there's a strict kind of legal statutes and laws that are in place. And then common law is kind of how those laws have developed throughout the years in the court system. That's a whole other topic. I don't want to bore you with a legal lecture, but that's a basic synopsis. But common law meaning in this instance, for the purpose of this video, is referring to cases, other cases that have similar facts to yours in which judges have made decisions in ways that you want them to, the judge here, to make a decision for you. So in your closing statement, now is the opportunity to go through that law, and you should come prepared with that law to help you support your case. And now's the time in the closing statement to do that. And once again, though, if you're in a court that there's no legal submissions allowed, or if that sounds overwhelming to you, you're just a regular person, so to speak, who's in small claims court, self-representing, don't get overwhelmed by that. You don't have to have law necessarily, especially if it's a very routine type of case. And finally, step 6 is to be polite and gracious. And this obviously applies throughout your entire trial, but especially when you're giving that closing statement, you want to thank the judge for hearing your case. Don't be overly flattery or anything like that, okay? Don't be disingenuous. You can do it authentically. You can really express appreciation. You say, Your Honor, I appreciate that you took the time to hear this case. I appreciate your consideration, and thank you once again. Something like that, okay? And again, it's a fine line between actually being gracious and polite and being disingenuous and just doing things to flatter. Don't flatter, because most judges will pick up on that scent, but to make sure to be polite and gracious is something that can really put you in a good light, rather than being obnoxious or argumentative the whole time or angry. You can argue your case. If the judge is challenging you, it's okay to argue your case, but always remember to be polite. This is the person that's making the decision. Okay, if you watch any sort of criminal trials online, for example, on YouTube, you'll see a lot of times these defendants at the end, before the judge sentences them, they read out this statement asking the judge for clemency or mercy and explaining what the mitigating factors are. And I would say in the vast majority of cases, it's their lawyer telling them to do that. Why? Because it increases the chances that the judge will have some compassion for them. Not always, obviously, depending on the severity of the case, but that's done to sort of recognize that the judge is a human being who's making a decision for you. So you want to make sure to acknowledge the judge's humanness, the fact that they took the time to listen to your case, and show that you do appreciate that. Of course, you have ulterior motives. Of course, you want the judge to find in your favor. But again, that's why it's kind of a fine line. You can actually be grateful to the judge without it resorting to flattery. If you recognize just how many cases the judge has to listen to and just how much of a hard job it can be. Now, that said, again, if you have more of an angry type of judge or impatient and you feel like the judge is going to read that in the wrong way, then don't overdo it. But there's certainly nothing wrong with saying a polite thank you for considering my case. All right. And generally, you should keep it simple and short. As I keep expressing to you, my audience here, that's what small claims court is about. It's about simplicity. I think a lot of life is about simplicity, really, but that's a subject for another time. Okay. But I know this isn't necessarily a legal pointer or hack or anything like that, but it doesn't make it any less crucial. This is based on a lot of years of experience that I've noticed that when plaintiffs and defendants too, but we're talking about a plaintiff in this instance, you're the plaintiff, you're the one suing. When plaintiffs are more polite and civil and gracious, they're in a much better position to win their case. Funny enough, it doesn't even necessarily have to do with the actual law. And that's precisely because the judge is a human being. And oftentimes a human being's decision can actually be swayed by emotions even more than logic in many instances. Okay, I'm not saying whether or not that's fair or right, but that's human nature in my opinion. In any case, speaking of summarizing things, let's do a brief summary of these 6 steps. So step 1 is to speak slowly, also politely, which I applied at step 6, but of course you should be polite throughout this opening statement, but make sure to speak slowly so that the judge can actually absorb what you're saying and take notes if it's a judge who takes notes. Step 2 is to restate your elevator pitch, really bring the judge back to what this case is about, encapsulate it in even one sentence. Step 3 is to summarize your evidence. Make sure to reference what evidence was heard in the trial. You can massage things that maybe didn't come out in the way that you hoped to bring it back to what they're actually saying. Make sure to reference that evidence, reference the testimony of witnesses who testified on your behalf. Make sure the judge knows where they can find all the evidence that you're referring to. Step number 4 is to summarize your opponent's weaknesses. Okay, make sure that you can show not only is your case strong, but the defendant's case is weak, and here's why. So you go through what the defendant testified to and what the defendant's evidence is, and go through why that was undermined by your evidence. Step 5 is to argue the law for those small claims court where legal arguments are allowed, and for those who are feeling proficient enough to argue case law. And if you're not, don't worry about this one step. And finally, step 6 is to be polite and gracious, not to a point of being inauthentic or flattering, but really to show appreciation for the judge, because the judge is a human being who heard your case. And yes, that can help you win your small claims court trial. So I hope you found this video helpful. If you have any comments or questions, you can leave that in the comments section below. Feedback is welcome. Once again, I thank you for subscribing. If you are a subscriber, if you haven't yet subscribed, it will take 1 second to hit that subscribe button and the notification bell so you don't miss a future video. Share this video with anybody who you think can benefit. Maybe you know somebody who's dealing with a small claims court issue now. And as always, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.